is in part heard appeal in the matter of Beard and the Commissioners for His Majesty's Revenue and Customs.
Thank you. Good morning.
Good morning, my lord. Morning, my ladies. Well, my lord, I have a quick gallop through a few remaining points. Lady Justice Falk yesterday gave a list of paragraphs from the First Tier Tribunal decision, which she said might contain within them findings of fact. Obviously, it would take me far longer this morning to go through all those paragraphs, so I have taken the liberty of writing down my comments on those paragraphs, which, with your permission, I would hand up.
Yes, those have been shared, have they?
No, my lord, it's the first I've heard of it.
All right.
I also have to hand up, well, there's 3 items that were referred to yesterday. I have the decision in Centrica Overseas Holdings, which you asked to see.
Thank
and
you.
I have the 2 items that were in the appendices to the experts' reports, but got omitted from the supplemental bundle because effectively that would have been, if we put it all in, it would have been far too long. So it's the Draft Companies Law Amendment number 9 and the Draft Companies Amendment number 10, which was referred to yesterday. So I will hand that all together. Thank you. The list of comments on...
Just get these under our belts. Thank you.
I'll just address the list of comments on Lady Justice Falk's paragraphs and the 2 that my learned friend also suggested. I have, just for your information, I have sidelined the relevant passages in the Centrica decision so that they're immediately identifiable for you on the capital nature point. The list of comments on the paragraphs may look a little bit more formidable than they really are. Some of the paragraphs effectively refer forward or back to other paragraphs, or at least by implication do. So I have added a few extra comments to try and make sense of the paragraphs that we're looking at. I have just three comments to make on that, and then I will leave that to speak for itself. The first is, as I said yesterday, the First Tier Tribunal decision contains a rather large number of infelicities about the way it actually talks about things. So, for example, it talks about Part 12 payments being distributions and things like that. Obviously, I have just pointed those out in the relevant paragraphs I've referred to, but that's just language of decision and so on. The key point, the 2 key points in relation to the First Tier Tribunal decision with which we take issue is the first, that the judge effectively, in the paragraph, talks about assimilation, and she defines it as assimilation. And effectively what she is doing in her decision is applying an English law perspective of what assimilates share premium to share capital, and trying to apply that to Jersey. But of course, the English law concept relies upon the maintenance of capital principle. In other words, that you can't pay a dividend of share capital. So that's not much use to you in a jurisdiction which has moved away from the maintenance of capital.
Can I just understand, as far as I can tell, this concept of assimilates comes from statements in First Nationwide. Is it?
I think that is.
That's the derivation.
I think that is correct as a derivation. I don't remember it being used before.
First Nationwide, no one really explains.
It was just the way it was referred to in First Nationwide. I can't now remember who would have originally coined that phrase, whether maybe I did in writing a skeleton argument for the revenue or what.
It may well even be in the first tier in the.
But I mean, it's not a. Although the Jersey law expert for the revenue sort of approaches it on the basis that this has some sort of established English law meaning, I think it is, as you say, my lady, just the expression that was used in First Nationwide. But anyway, she.
As I understand it, though, also just because it's used so much, I just want to press this point a little bit. I understood it to refer to essentially Article 839(4), which is the provision that says that share premium broadly is treated like nominal capital for the purposes of reduction of capital.
That is correct, my lady. I think that's the sense, when I say that's the sense in which it's being used, but it's being applied in the decision on the basis that therefore, as you cannot distribute nominal share capital, if the share premium can be distributed, then it's not assimilated to nominal share capital. But of course, that's an English law approach or English perspective of the effect of Article 39(4), but you're now dealing with a jurisdiction which doesn't apply the maintenance of capital principle. So the issue is, well, now, why does that English law concept apply in the same way in Jersey, in a jurisdiction which has abandoned the maintenance of law principle?
Okay, so that's your first key point.
That's the first key point. The second key point, which really derives from that, is if you're looking at a jurisdiction such as Jersey, and you only look at half the picture, in other words, share premium as one of the capital accounts, and you completely ignore the other half of the picture, which of course is not no par value companies and the stated capital account of the no par value company, how can you arrive at a correct conclusion as to how Jersey regards share premium? It's a bit like, to take us to a very simple illustration, if I look out of the window looking east and see it's clear blue sky and say it's going to be a lovely day, and I omit to look out of the window to the west to see it's either pouring with rain or the storm clouds are gathering, my opinion or the conclusion I've reached that it's going to be a nice day by looking out of one window and not having regard to the other is not going to be an opinion that you can rely upon. And here I say both the revenues expert witness, but also who applied the same assimilation of capital type approach, and the First Tier Tribunal effectively looked out of one window at share premium and completely ignored what was going on through the other window of no par value shares and stated capital accounts. Because of course anything they decide, or their reasoning in relation to share premium must apply equally to stated capital accounts of no par value companies, not least because at the later stage it's made clear that the two can be treated in the same way. So does that imply that a no par value company has no capital because it's not it doesn't have a par value and is not therefore assimilated to par value share capital at all? It's assimilated, or perhaps I shouldn't use that word, it's treated as if it were share premium. But I went through all of that yesterday. I won't take more time on that. And it's exactly the same criticism that I say applies to the Upper Tribunal decision in the core bundle at page 80. One sees, starting at paragraph 66, what the Upper Tribunal, sort of where it reaches towards its conclusion on this, and says that the First Tier Tribunal decision is obviously correct and can't be overturned. I obviously take issue about their inability to actually look at the other side of the picture.
What paragraph were you just referring to? I'm sorry, I'm catching up.
My apologies, my lord. It's
page
the core
66.
bundle, page 80 in the 80 of the core bundle.
Thank you.
And it's beginning. I was just picking up at paragraph 66, where they refer to Edwards and Bairstow grounds, which I take issue with, as I made clear yesterday, but I'm not sure I should say any more about it now until I heard my learned friend pursue that particular point. But you see in particular, as they go over the page, in particular, paragraph 68 on page 81, applying the method of distribution test. Once a distribution of share premium is made by the mechanism under Part 17, the payment is not of a capital nature. The company is not using a mechanism which covers a reduction of capital of a company. That mechanism is in Part 12. But that conclusion is reached effectively by adopting the same sort of approach as the First Tier Tribunal, that you apply English law concepts which rely on maintenance of capital to a Jersey entity and a Jersey system of company law that has moved away from that, and therefore must at least demand a different perspective or view as to what it regards as capital and what it doesn't regard as capital. And of course, we say that here the facts as agreed are that this was contributed for share premium, which was recorded as capital in the capital accounts and returned to shareholders by being debited to the capital accounts. And we say that those facts, when you look at the way in which the company law system of Jersey works at this time, means that the payment that's received is of a capital nature. So that's essentially our point. But insofar as it's still the view that somehow corpus has to enter into the matter, and one has to therefore ask in some way, well, how was the corpus of these shares impacted by these distributions? My simple answer to that is, well, of course they were impacted, because the liability on the share, and we saw how share premium was allocated between different classes and all of those provisions of the company's law. I went through them yesterday. Of course, the amount recorded as outstanding as a liability to shareholders in respect of those shares is reduced by the amount by which the share premium account has been debited.
Yes, I mean, when you say liability to shareholders, that's an entirely notional liability. If you looked at, for example, what these shares would be entitled to on a winding up, we haven't looked at it, but I'm pretty sure it would not say first pay off the capital, the nominal capital and the share premium. It would say surplus assets go to the ordinary shareholder.
Yes, but I think as a sort of general approach, you recognise that the value of the company is not necessarily related to things such as either the value of the shares necessarily. I mean, if you're talking about a liquidation basis or something like that, or even the amount of the liability on the balance sheet. But what you're looking at is the shareholders' interest in the company, which is reflected in both the share premium and the nominal share value. If you're dealing with a par value company, or in the stated capital account of the company, if it's a no par value company, and that, as recorded in the balance sheet, is reduced by the act of debiting that particular account.
Do we have the complete articles of this Jersey company?
Apologies, my lady.
We have the complete articles of this Jersey company.
The simple answer to that is yes, they were in the original hearing bundle, but I don't think they're in the...
Okay, because if you're relying on share premium, and you've made this point several times, as effectively a liability to shareholders, that for me prompts the question I've just asked, which is, well, what does that really mean? Because I'm not sure I would expect the articles to be written.
There are obviously some of the provisions of the articles in the agreed statement of facts dealing with the distributions. the article, the full articles, I
Right,
think,
I-
were in the original First Tier
Yeah,
Tribunal.
okay, I'm reluctant to ask for more documents to be sent or handed out.
Indeed, my lady, but I mean, I think if you, if we're talking about certainly the conception of share premium as a, when I say as a starting point, if one goes to the authorities bundle at page 915, I mean, this is just a small point in response to your question, my lady, but if we look at the Cohen report, which of course was the report which said share premium is essentially capital and therefore as a matter of company law it needs to be treated as capital, leading to the 1948 Act. If you look at page 416, all of that discussion about share premium falls within the section of the
416.
916, my lady. My apologies, 916. It all falls within the discussion of the accounts of the company and therefore how the balance sheet and profit and loss should be dealt with. Although the what it says about the recommendation it makes in relation to share premium comes right at the end of that section on page 927 of the authorities bundle. All of the discussion leading up to there is about, well, you know, how do you record these things in the balance sheet of the company, and what should be recorded there in terms of the earnings and profits, profit and loss, and how should it be dealt with on the balance sheet. So the whole object of putting it into a capital account and on the balance sheet is to record it in the balance sheet as part of the capital, and as such it is on the balance sheet a liability to shareholders. And that obviously, if you're thinking about corpus, that's reduced. But the only point I was going to make about corpus is a point that we deal with in our skeleton argument. And just for your note, so that you know where it is in the skeleton argument, it's in the core bundle at pages 38 to 41. It's paragraphs 63 to 73 of the skeleton argument, and that of course relies upon the decision I took you to briefly yesterday in Duff.
Yeah. Thank you.
So that's the First Tier Tribunal, the Upper Tribunal decision. The expert report, as I say, by the Revenues Expert Report, it's not clear to what extent, as the Upper Tribunal observed, it's not clear to what extent the First Tier Tribunal actually relied on that. There are, as I've got in my note on the paragraphs you drew attention to, my lady, I've shown where she derives the material from the joint report of the experts. Not always 100% accurately, but you know what she's referring to, even if she doesn't quite repeat it in the same terms. The expert report for the revenue again omitted any consideration of no par value companies. It relied very, very heavily, as you read the report, not least from the definitions that it concocts at the opening of the report on the maintenance of capital principle and the English law authorities, all of which are concerned with or are in the context of the maintenance of capital principle. And then it applies a comparative law approach. If we just go to the one paragraph of the Revenues Expert Report in the supplemental bundle, and it's at page 155. Where he says at 981, it's my opinion, the Jersey comparative law principle that differentiates between Jersey statutes and non-Jersey statutes on which they're based should be assumed to be deliberate, effectual, etc. And then at 3, he says, unlike the assimilation question where Article 39.4 equivalent provisions are close, that's the point that you made, my lady, initially, if not identical, for reasons I shall go on to explain in this paragraph, the manner in which English and Jersey company laws have dealt with what under Jersey law I refer to as Part 17 distributions are very different. Now, the expert for the taxpayer, Mr. Fenton, effectively said, well, if they're very different, you can't use a comparative law approach. In other words, you can't take English law authorities and just apply them in Jersey in that way. And that takes us, just in terms of, I say the way in which Mr. Wilmot then goes on to try and he looks at various jurisdictions and says, well, he can't find anything comparable there. So for want of anything better, I'll have to go back to the UK, and then he tries to construct weightings to decide things. But if we look at the decision of the Jersey Court of Appeal in HWA 555, which is the authorities bundle at 863, this is a decision, as we see, of the 13th of June 2023 by the Court of Appeal in Jersey. I'll just note several points here just to pick up what was said yesterday as to the use of expert evidence of foreign law. You can see.
Just to be clear, this postdates the FTT's decision.
It does indeed.
Yeah.
The use of expert evidence of foreign law is appears at paragraph 5 on 864. Just to make the point that, of course, if there were a question as to English law authority in the Jersey courts, they would be seeking expert evidence. Could be seeking expert evidence in the same way as we do here.
Sorry, did you say paragraph 5?
Yes, it's toward the bottom. You'll see at the bottom it says the Royal Court found that the lease and guarantee were governed by Californian law.
Yes.
And obtained expert evidence of that. Now, there's no reason why, if you're actually in Jersey and what you want to do is to rely upon the English law authorities, why you shouldn't seek expert evidence of English law. So there's all the discussion that is entered into by Mr. Wilmot in relation to the English law authorities would be material that's perfectly capable of being given as expert evidence in a Jersey court. And the question is, how would, if we were asked, how do these authorities apply to a jurisdiction which has abandoned maintenance of capital as a principle? You know, what would we draw from that? That's just one point. And then in relation to the use of extraneous matter, which came up yesterday, I said that there was illustrations of that in this decision at page 70 on paragraph 26.
Sorry, page 870.
870, my lady.
Thank you.
It's paragraph 26, where they say, given the arguments over the proper construction of the new provisions, it's legitimate the report attached to the project of these regulations. In other words, they're looking at some of the material that was produced as part of the regulations, but there are other illustrations of use of extraneous material in paragraph 56, that's on page 877, in paragraph 108, that's page 891, and paragraph 170, which is 907. So the extraneous material was used by the experts in rendering their opinions on these matters, and you have some of that. But it also appears that it can be relied upon by the court. But the principal thing we look at this decision for is at page 875, which discusses in terms of when it is appropriate or not to adopt a comparative law approach and in looking at authorities from other jurisdictions. I mean, I think it's fair to say in the First Tier Tribunal decision, Mr. Fenton, for the taxpayers expert, is rather suggested that you couldn't do it, but that's not what he said. He said, of course, you can, if it's appropriate to do so. But if you're looking at a completely different system, what can you derive from the authorities of a different jurisdiction which adopts different principles, in this case, relating to maintenance of capital?
So that's
Gary, could I just,
give me a reference for that?
Sorry,
The reference for which you're referring to the evidence?
Oh, yeah, oh, well, okay, may I give that, if I can do that shortly? I think I'll have to look up the specific reference, but it's covered in, it's one of the paragraphs which you didn't highlight in the First Tier Tribunal decision. But I've got I can refer to it. If you hold on a second. Oh,
Yes,
with your leave, I'll
perhaps
I'll
that
give
can
it to
be,
my learned friend in
that can be
due
dealt with in the course of the day.
Yes, I will do that.
My intervention was in the nature of the, as it were, the bell.
Yes,
for
yes.
the
I see
final
I
lap.
have about 3 minutes.
Thank you.
I think I have dealt with everything other than just to refer to the Lonmin decision. The Lonmin decision, all I want to do for that, I think, is just to refer you to where you find the facts of the Lonmin decision. In the supplementary bundle at page 113. Where you see the initial 113, you see the initial published press release about the return that Glencore is going to make of its 23.9% stake in Lonmin PLC. And then at page 96, you see the more detailed prospectus or memorandum that was issued with the notice of the AGM, in which the details of the Lonmin distribution are given. It sets the timetable of events, provides a description of the distribution, explains that the distribution is made pursuant to Article 813 of Glencore's Articles of Association. If you'll note, you can see Article 813 of the Articles of Association in the supplementary bundle at page 8. Confirms that the Lonmin distribution will not impact Glencore's cash distribution programme, and explains that fractional entitlements will be sold and the proceeds retained by Glencore. And then it gives several pages details of the managed sale programme for those shareholders who want to dispose of their Lonmin PLC shares rather than retain them. At page 107 of the document, you can see that Lonmin or Glencore has been advised that the Lonmin distribution will be treated as a capital distribution for UK tax purposes. On Mr. Beard's case, and as indicated in part 3, we say there's no different treatment for UK resident shareholders as a capital distribution, whether they choose to retain or to sell their Lonmin shares. I mean, they're held. If they're sold, of course, that's a capital gains tax disposal by the shareholder. But when they're acquired as a capital distribution and taxed as such. This is not a dividend in the ordinary sense of the word, and we rely on MEMEC and what it says about distributions to say this is of a different character to the type of distribution that we've been looking at for the cash Glencore dividends. But even if it were to be a dividend within the meaning of section 402, this is, we say most obviously, a dividend of a capital nature, because that's effectively the nature of the transaction and what they're getting under this particular mini demerger, straightforward passing of assets that have been acquired in the ex strata merger by Glencore to their shareholders, because they're not core assets for Glencore, and they would be better managed if they were owned by the Glencore shareholders and who could do what they want with them.
Mr. Gemmy, very quickly, you took us to Article 8.3 in
Yes.
relation to Longmin. We haven't otherwise been taken to the articles. Were the cash distributions made under Article 8.3? I've got the impression there was a change of the articles at some point.
That's-
during the process.
That is covered in one of the paragraphs you drew attention to, so I've sort of made some notes about that.
All right,
I
I'll
don't-
look at those notes if they.
I mean,
make sense.
in the agreed statement of facts, we're given details of the shareholder resolutions that were put where they needed to be put for a final dividend, for example. But I don't think we know what the sort of internal processes were, and I'm not sure, apart from the Lonmin distribution, where we know from the public documents, I'm not sure, maybe my learned friends will point to something that says otherwise, which article it was paid under.
Thank you.
Yes. Thank you,
Well,
Mr.
unless I
Kelly.
can help you further at this stage, I
Thank
will.
you very much.
I'm only 2 minutes overdue.
Yes, Ms Yates.
Thank you, my lord. Just one observation in terms of this document, which it's the first I've seen this morning. I'm not in a position to respond to a 12-page detailed commentary on all the paragraphs at the moment. This is the first I've seen of it. The other complaint I have with the document, leaving aside its length and the lack of notice, is it doesn't actually identify what is, on Mr. Gammy's case, an error of law, what is an infelicity, what is the underlying evidence which supports why something is an error of law. There are some references, for example, to the joint memorandum of experts. But what we're not told, and it's not for me to guess or go away and figure it out, what we're not told is why this fed into a critical error of law which would justify this court intervening. And ultimately, I think this will be Mr. Gammy's submission, although he hasn't said it out loud, superimpose your own view of Jersey law, or potentially, again, we're not told, remit back to the First Tier Tribunal to make fresh findings of Jersey law in light of the criticisms made.
Well, until we're told we're being asked to remit, I've approached the matter at a high level basis that Mr. Gammy's submission is effectively that it's so clear that the tribunal was wrong, that, as he put it, we're perfectly capable of making our own mind up about it. So I take your point about the document, and the length of the document will be read with that in mind to the extent that we need to read it. And as to the submission you make about it is effectively that it's for the appellant to make his case. And you say this doesn't do so, doesn't explain.
Can I take a
Right.
couple of examples, if I may?
Yes.
In the short time I had to read this. So if one turns up page 4, and at paragraph 66 sub 9, there's a statement which on the left, which is the tribunal, the experts were agreed that if the Jersey legislature had intended the amendment, which introduced part 17 to have the effect of
Sorry.
66.9,
page 4, 66.9,
for example.
for example, yeah. Express language would have been required to achieve that. Mr. Gammy's comment is, this is inaccurate, and he says, this is the actual reference. My response is, well, so what? Is that an error of law? Is that an infelicity? Are we to rip up the entire FTT findings because of that? Or are there some of these comments, which this document doesn't tell us, some which are critical, some which are nitpicking? I just don't know. And maybe this would be an opportune time for Mr. Gammy to enlighten us as to which of these findings are critical and which are not. Because otherwise my submissions in terms of trying to respond to this is effectively a futile exercise. I don't know if Mr. Gammy is able to tell us, or even if he knows what his case is, as to which of these flaws are critical errors of law which invite this court's intervention and which are just Mr. Gammy's observations. Another one, for example, is if we turn up the page at page 6, This is item 200. You'll recall there is a finding by the FTT that the way these dividends / distributions were recorded by the company was changed, and the tribunal has essentially made an inference that this was because of Mr. Gammy's advice. Mr. Gammy's comment is, it is not known what circumstances or on what terms HMRC obtained a copy of Mr. Gammy's opinion. Mr. Hitchmo, that's HMRC's counsel before the first tier, may have asserted this, but no evidence was produced to substantiate the basis on which the company chose to act. The point has no relevance to the issues under appeal. So this seems to just be a nitpicking complaint, albeit it's not one this court could interfere with. The tribunal was clearly entitled to make an inference of fact, and there's no challenge in the grounds of appeal, for example, going towards that. So what one would normally expect in an appeal when one is challenging findings of fact, even if they are Edwards and Bairstow light, is to have a list of matters which are said to be areas of law, a linking of that to the underlying evidence before the tribunal, and then a linking of that, call me old-fashioned, to the grounds of appeal. That is not the exercise Mr. Gammy has engaged on. Rather, what has occurred, and at length yesterday, is a lecture, essentially, of Mr. Gammy's own thoughts on the nature of Jersey law, and why, because the FTT did not conform to that view, it must have therefore made an error of law. Now, if that's the only point being made, so be it. But if that is the case, I'm not sure what this document is therefore aiming at. That initial whinge over, if I can then turn to what the revenues case is here. Just to give you an idea of the figures at stake here, just to descend from the ivory tower of what the law should be, the UT and the FT both set these out, but the easiest way to find per year what these figures are is actually in the Upper Tribunal decision. If we just turn up that core bundle now.
Yes, we know they're very large.
They're very large.
That doesn't, obviously doesn't determine their capital.
It does not, no. They're very large, but they're very periodical. You essentially have two sets of dividends per year. The total amount is 149 million. For the last year, there's the figure in the UT decision of 42 odd million. Just to put in the context of the significance or otherwise of the Lonmin point, unfortunately, what the UT has done is quote from, and again, if you wouldn't mind just turning this up, because it is useful to see. If you turn up page 66 of the core bundle, it records the sterling value of the distributions, and it's quoting from a document called Statement of Agreed Value of Distributions Received. Now, that document isn't in the bundle, and it doesn't really matter, but for this point, they've left off one paragraph, which is the value of the Lonmin distribution as part of that last line in 2015-16. And the Lonmin figure is a figure of 4.7 million. So put in the grand context of the appeal, of all the in sterling, of all the amounts we're concerned with here, the Lonmin distribution is about 3.2% of the total value of distributions that Mr. Beard has received. It's obviously
right, and it's included in your 149 million, but not in that chart. Is that it?
Correct, but it was agreed. It's
Right, so
in that
it
document,
would have been,
which is partially quoted.
But for the Glencore, it would have been a respectable tax case on its own.
Well, yes, yeah, absolutely. But just to give you a sense,
What does I mean, as my lady has said, I mean, if you'd knocked off six figures at the end of all of this, it would still have been an issue. So what does the amount help us with in terms of whether it's a dividend in Lonmin's case or whether it's capital in both cases?
Well,
how does that matter?
It matters because it might be relevant to the submissions on Lonmin, to the extent you engage with a sort of Sinclair and Lee analysis. Because Sinclair and Lee...
Well, do you mind, I mean, can we talk English for the moment? I mean, rather than diving into concepts, why does the amounts, which are very large in this case, matter to the task that the tribunals have had to conduct?
The revenues case is threefold. First, there's been no change in the law. So the old case law is valid and more than that, binding. Because the question of capital is a matter of law, not a sort of question of pure fact. Second, if that's the case, what on earth does a dividend of a capital nature mean? And the revenues case is, well, that's not intended to change the law. The old law, Schedule D, Case 5, was purely a tax on income. So the draftsperson, when they came to draft 402, wanted to exclude, if it were possible, dividends of a capital nature. Now, when we come to the question of, well, what does that residual category actually mean? What the best explanation for that in my submission is in the UT's decision at, I think, paragraph 75. Essentially say it could encapsulate a situation such as were the facts of Sinclair and Lee, which, my lord, was an indirect demerger, where ICI was split up into essentially two companies. One, the old chemicals business, the next, the pharmaceuticals business, Zeneca, it's now AstraZeneca. And Zeneca was worth probably 55% of the company. So it was, on any view, as a matter of substance, if not as a matter of form, a massive splitting of what was a single enterprise into two distinct businesses. And the issue the Vice-Chancellor grappled with was, under the trust rules as they were at the time, he was potentially being forced to say, well, that's all income, that's all going to the life tenant, because it took a form of a dividend. And one of the issues which is engaged with in terms of the Lonmin shares is, well, is the Lonmin distribution comparable to that? Now, that's a point my learned friend, Ms. Blanche, is going to be making submissions on after my submissions on the Lonmin point. It's a short point. And so I don't want to steal her thunder. But the point in terms of value is, on any view, this Lonmin distribution was not remotely comparable to the facts of Sinclair and Lee. And that's why the value
Still,
on a comparative level matters.
I'm sorry. At the moment, speaking for myself, I'm not understanding. I mean, why? I mean, you know, 4.5 million is a lot of money to some people, and so why does it matter that it's 4.5 million rather than 400,000 or 40,000?
The absolute figure does not matter, my lord.
Well, that's my only point. I mean, in the context of Glencore, which is one of the wealthiest entities on the planet, the figures are bound to be large. But surely what applies to Glencore has also got to apply to a small business.
The point is the relativity, isn't
Indeed.
it?
The Lonmin shares were a pinprick in the value.
Yeah, I think maybe it's better. Your point may be better understood as relative to the size of the normal interim and final distributions, dividends, which you can see on the page, were very substantial. You're saying relative to that, the number was very low.
Indeed. Or you could say the total value of the distribution of the Lonmin shares relative to the market
It's
capitalization.
a Lonmin point, is it? Is scale a Lonmin point only?
It's a Lonmin point only, exactly.
Right, and is it, because I'm sure, is this a point that was taken up by the tribunal?
No.
Right, so what's it doing here?
Well, Mr. Gammy reserved his position. He says, treat them all the same before the FTT. But I'm going to reserve my right to say it's somehow different on appeal if I choose to, and he's chosen to do that. So there's a complaint made, well, you've treated the Lonmin shares all the same. That's what Mr. Gammy invited the FTT to do. So I can't. Right.
So it relates to Lonmin. It's to do with, not to do with size, but to do with scale or relativity.
Indeed.
And it's a new feature of the argument.
It was not a point the FTT was asked to decide.
Yes.
Separate from the main treatment of the cash dividends. So, as I said, there's three overarching points. 402 was not intended to change the law. Now, I troubled your judicial assistant yesterday by handing up some notes which showed the explanatory notes both to the bill and to the Act in Annex 1, and I shared those with Mr. Gammy yesterday. And all those demonstrated there's a gap between section
Just
400.
one point of order.
Yes.
We were taken yesterday to the explanatory notes on the bill,
Yes.
which I'm not sure are readily published in full. It's obviously easy to find on the Gov.uk website the full notes to the Act. I haven't looked hard, but I can't see myself access to the full version of the bill. You've helpfully provided details of Annex 1. We've got extracts in the bundle from the relevant section. For myself, it will be helpful to also have the opening section of the explanatory notes, which in the Act, I think they're under a heading of the notes for the Act, have a series of paragraphs at the start, some of which in its Act form were also considered by Mr. Justice Sales in Eclipse. I think it's something like paragraphs 1 to 9 in the Act. I'd be very grateful to receive that, a copy of that those initial paragraphs from the bill. Just because for consistency, if it's technically right, which Benyon certainly thinks it is, to refer to the bill rather than the Act, then it would be helpful to be consistent.
Point taken, my lady. Yes, we'll supply those. So no change in the law. Mr. Gammy, I think a copy of Centric has been brought today, which obviously was concerned with whether capital expenditure, whether expenditure was capital or not, whether that was a matter of law. Held yes, actually that was established in a 1990s case.
Yeah.
In relation to receipt, that has, I'm quite content to accept that that is a matter of law. Not really so much on the basis of Centrica, but if my lady recalls in a case you were involved in, which is Bluecrest, the Dodd appeal, Lord Justice Henderson, albeit I think obiter in that case, was of the view that the question of receipt was a pure question of law as well, albeit it wasn't subject to full argument before him. That's the best reference I have of that.
How does that play into this, other than, I assume it's not, the word isn't used, but
Which word?
well, receipt isn't used,
No.
isn't it? But
No, but whether an item is capital or income in terms of the hands of the
Yes.
taxpayer.
yes, so just to be clear about this, it is a matter of English law, is it not? Not Jersey law, whether what was received by Mr. Beard is of a capital nature.
I would say UK law to be accurate,
Yes,
because we're dealing with a UK taxing
so
statute.
you're quite right. Obviously, you start with Jersey law, and I assume you take no issue. We were taken yesterday to a passage from Lord Justice Moses' judgment in Memec about the correct approach to adopt, which is you look at the local law and then you apply English law or UK law to it.
I'm
I'd
good
be
to,
grateful to understand if you take issue
I will
with that.
develop my submissions on that point,
Thank you.
because there is a slight degree of confusion, if I may say so, on that point. It's absolutely vital you look at the foreign law when one's dealing with an entity which is a creation of foreign law. And you have to understand what are its foreign law characteristics and what are the foreign law characteristics of the mechanism, as we'll come on to see, which is being used. But sometimes you see in some of the reasoning a label used such as capital. Foreign law regards this as capital. In my respectful submission, that's slightly inaccurate. The question of capital and income is a UK tax law concept.
Indeed.
Foreign law might not even have that terminology. There's always a danger when one is looking at an English law jurisdiction, whether it's Jersey or maybe Maryland, to say, well, I'm an English lawyer, I know what capital and income is. Surely a Maryland or Jersey lawyer, if they even thought of that concept, if it was
Yes.
relevant, has exactly the same meaning.
That prompted my comment yesterday that I thought the experts in this case had strayed into areas that were not their province.
I think that's a very fair criticism, my lady, yes. Because
But I would, you will, I'm sure, develop your submissions, but I would like to understand how, what you say is the division in this case, on the facts of this case, between Jersey law and UK tax.
Well, my submission is that under the previous case law, the pre-Atoya case law, the question of whether a receipt by a taxpayer was capital or income is determined by the mechanism used. That is the same as the corpus test in my submission. It's part and parcel of the same exercise. It can get confusing because in one breath, Lord Reed or whoever talks about, the mechanism is determinative. And then a page on, it's talking about the corpus. It must be the same exercise in my submission, because ultimately all that corpus is a shorthand for has the capital of the company, and again, we have to be very careful using that word, has that been affected, diminished, or whatever word you want to use, by the mechanism used? And that becomes much clearer when one looks at the judgment of Lord Justice Moses in First Nationwide. It becomes very clear that the sort of noise dissipates, and it becomes very clear when you read First Nationwide that mechanism is king for the purposes of determining whether a receipt is income or capital.
Okay, was that you said there were 3 main submissions. Was
I've got
that
another
your
one.
first? Okay.
Where
I've lost
did
count.
the second one
So
start?
first one, no
First
change in the
one,
law.
No change in the law,
Second, we can just have a slogan, mechanism is king.
right?
Or put it another way, there is no separate holistic inquiry in parallel carried out as to whether this separate concept of corpus is affected. It's part of the same exercise. The third point is both the pre-Atoya case law and the current case law both envisaged that it might be possible to characterise a dividend as being capital in nature.
Pre and current case law.
Sorry, both the pre-Atoya case law and the current legislation. I apologise.
Allow for capital dividend.
At least it hadn't ruled it out as a potential concept. The only example anyone gives, both the Court of Appeal in First Nationwide and the Upper Tribunal in this case, is Sinclair and Lee.
Okay.
But what the Upper Tribunal obviously does go on to makes the same point as my lady made yesterday. The innovations of foreign law are potentially countless, and what the draftsperson of 402 has tried to do is, just in case you do happen to have something very to a UK company lawyer, very strange, which is a dividend of a capital nature, I'm going to keep that out of the what is only supposed to be a charge on income.
I mean, on that point, I mentioned this to Mr. Gammy yesterday, and he drew my attention to what Lord Justice Moses said about it. But there are references in Courtauld and Fleming, not just in the head notes, to the directors of the Italian company having decided to pay a dividend, but they didn't pay it as an ordinary dividend. They did something which Mr. Justice Buckley ultimately found to be capital.
Yes.
And it did strike me that, despite Lord Justice Moses' comments, which of course post-dated the enactment of Atoya, someone might have had Courtauld and Fleming, which is one of the key cases, in mind.
Potentially. The other difficulty with Courtauld...
It's approved by the House of Lords, so it has...
It is... Courtauld is a very compressed case, where both the findings of Italian law are compressed, and with all due respect to Mr. Justice Buckley, his reasoning is also compressed. In particular, the finding that Italian law says this is capital, that itself is quite a compressed.
I agree, but I'm simply responding that as a possible response to, there can't, the argument that there can't be a category of dividend of a capital nature if the revenues case is right, and leaving to one side Sinclair and Lee, which of course relates to a UK company, something that was a dividend in UK terms and would have been income under UK tax principles. So it's not Sinclair and Lee isn't a totally straightforward case.
No, it is not. It means what Sinclair and Lee is really about, both Sinclair and Lee and Ray and Lazard are both demergers.
Yeah.
actually very similar.
Mm.
What the difficulty for the Vice Chancellor in Sinclair and Lee is he didn't have a nice Maryland concept of a partial, of a distribution and partial liquidation. He would, one infers, really would like to have had that.
His difficulty is evident from his very careful reasoning.
Yes, I think he's pushing
Yes.
binding authority.
Mm.
He's right up against the limits of it. But those are both actually economically, not legally, but economically very similar cases. And the misfortune for the trust law analysis, obviously, one was dealing with an English company, where this concept of a distribution partial liquidation just didn't exist. They had to use the mechanism of a dividend, albeit not a dividend. And I think this is a points are going to be addressed by my learned friend Ms. Blage. It's not a direct dividend, as it were, to the shareholder. It's essentially a dividend which is satisfied by another company issuing its own shares, new company issuing its own shares to the existing ICI shareholders. But it is odd facts, but it undoubtedly does involve a dividend in form. And what the Vice Chancellor was essentially saying was, whilst that is in form a dividend, I'm going to properly characterise it as essentially a reorganisation or restructuring. Now, just in terms of, so those are my 3 points. Now, in terms of what I can say about Mr. Gammey's challenge on Jersey law, or to the FTT's findings on Jersey law, I quite accept what my Lord coined yesterday, that the concept of Edwards and Bairstow light may be appropriate. One is dealing with a foreign law which is not unfamiliar, let's say, to an English lawyer. Jersey law is obviously not common law. It's customary law, Norman customary law, I think, in practice. And there is obviously some commentary on that, I think actually by Mr. Felton, Mr. Gammey's client's witness, as to why that does mean it is actually quite different. But we are dealing obviously here with a statute rather than sort of free-floating concepts of case law or whatever. We can obviously all read what the statute says. I'm not going to make an unrealistic submission that you can't at least appraise what that statute or the mechanisms set out in that statute are. But nevertheless, this is still a challenge to findings of fact. What Mr. Gammey can't do is make some high-level commentary in terms of pure submission as to how Jersey law should operate, which isn't tied specifically to the criticisms of the FTT judge or to the specific evidence which was before her. And indeed, one big missing piece of the puzzle, which is surprising in my respectful submission, is the oral evidence, which lasted a full day, oral evidence of the expert evidence, lasted a full day. That is a black box to this court. We have been, and that is despite the fact that if one looks at the FTT decision, the judge is fairly engaging with, obviously not with what is just set out in the written reports, but what was obviously put to the experts in their cross-examination. So, in my respectful submission, and parche whatever is set out in Mr. Gammey's note, Mr. Gammey can't possibly demonstrate that there is an Edwards and Bairstow error of law, whether one is applying a light test or otherwise. Effectively, what he is inviting you to do, is to appraise the matter de novo, not by reference to what the experts actually said, either in their reports or in their oral evidence, but by reference to Mr. Gammey's own appraisal of the Jersey statute. That is tantamount to what happened yesterday. Thus rendering pointless, I think on his case, the whole need to even call expert evidence, because it would have been open to him to make, presumably, exactly the same submissions before the FTT. in any event, if one were to engage with Mr. Gammy's criticisms, and in particular the core point he focused on yesterday, which is at paragraphs 248 to 252, that those should be rejected on their own terms. His real point is that, although it has taken him a long time to develop this submission, his real point is that share premium ought to be regarded as capital under Jersey law, and it doesn't ultimately matter for a UK tax law analysis which mechanism is used to return it. It should always be regarded as a capital receipt. I don't want to try and frame Mr. Gammy's case for him, but I think that is what he is saying in the space of a sentence.
Yes, I think he's saying that if you return share premium, whether under Part 12 or Part 17, Part 12 being the formal reduction of capital, Part 17 being the distribution, makes no difference, it's still capital. That, in essence, I think is the point, as I understand it.
It is, I think. But obviously, it does beg the question, what is the term capital doing in that sentence? What ultimately the FTT decided was that share premium under Jersey law had an ambiguous status. It makes that finding really at 251 and then at 264. I don't know if it's worth just bringing those up. Earlier on, there had been a discussion which the FTT had about share premium in general, not necessarily specific to Jersey law, share premium in general having a chameleon-like character, if you recall that. And that was endorsed by the Upper Tribunal. But if one goes to the FTT's decision at 251, which is on page 141, so I do not think that this can be correct. On my analysis, even taking into account Article 39(4), my view is that Part 17 overrides, this is obviously the contentious part from Mr. Gammy's point of view, the assimilation to capital provided by Article 39. The deeming provision at Article 39(4) is made subject to the ability of a company to pay a distribution under Part 17. The legal character of share premium as assimilated to capital is broken by Article 39(3)(e). That's the bit that allows you to distribute it under Part 17. And payments made under Part 17 cannot properly be treated as anything other than distributable profits. Now, there's a couple of infelicities there, which I'm sure Mr. Gammy has commented on his notes. But that's the basic point. And then if one goes on to 264, there's again a debate about, the judge engages with the evidence of Mr. Wilmot, including his oral evidence. 263 is clearly talking about his oral evidence. And the judge then makes a finding that gives share premium for Jersey law purposes something of the character of Schrodinger's cat. Mr. Wilmot resisted the suggestion, it's obviously a suggestion made in cross-examination, that the share premium account was anything other than essentially capital ab initio, but did not suggest that its character depended on...
Did suggest
that its character depended on a decision by the company about how it was to be paid out. And what Mr. Gammy's objection is, and I'll come on to show why this can't really be the right analysis, is the manner in which you pay it out can't alter the capital nature of the receipt. Essentially, and this is really his 3 R's point, again, a test of his own coinage. Yeah, what's capital coming into the company and treated as capital in the hands of the company must be capital in the hands of the recipient. Now, as complicated and sometimes confusing as the law is, the one thing I will absolutely be able to show you is that's completely wrong as a matter of UK tax law, demonstrably wrong.
Well, capital in is not capital out.
No, or not necessarily, I think is how it's certainly possible, and you'll see comments when we come to the cases. You can obviously capitalise profits, so you can turn income into capital in the hands of a company, and then if you then use a reduction of capital, that will be a
Yes,
capital
I mean,
receipt.
just on that, I think the Upper Tribunal records that it's common ground between the parties that if these amounts had been paid out under Part 12 on a reduction of capital, they would have been treated as
Yes,
capital. Is that the case?
I'm not going to depart from that. Mechanism is king, as my submission says. So if you use a capital reduction mechanism, it's a capital receipt.
I don't want to ask you to speculate, but was there an explanation of why the distribution was under 17 rather than 12?
No,
If that's not explained, then I don't want to get into it.
the only thing I'm very happy to speculate, but
No,
I
I don't
can't do
want you
any
to
more. It
speculate.
might have complicated the Swiss tax planning for all I know, but it's obviously simpler, administratively simpler to use Part 17. I think that is recorded in the
I think
decision.
the other thing that's certainly clear at the start of this process, until 2014, Part 12 would have required court approval.
Indeed.
The Jersey law then changed. I think that's the effect of the Amendment 11, if I remember.
Yes, the court may still approve.
Yes, but I think one answer may be, there is evidence from the papers, is that you would originally have had to get court approval.
You would. Very much like the English system. And again, the English system has, the UK company law system has moved on as well. Albeit, as I understand it, you sometimes very well advised to get court approval, despite the fact you think you may have satisfied yourself under a UK company law system, because obviously once the court approves it, it then can't be questioned by a third party coming along later. So,
Well, just pursuing not the speculation, but just my understanding of what the system is. If you want to pay out capital, then there may, depending in different jurisdictions at different times, there may be procedures that you have to comply with in order that should be securely achieved. And they're different to the procedures that have to be gone through in order to pay a conventional dividend. So there is a reason why there are two different systems.
yes, my lord.
And if a company decides to use one system that is apt for a certain sort of exercise, the conclusion of the tribunal seems to be that tells you something.
The conclusion of the way the case more
The
generally.
use of Part 17 was regarded as significant when there was an alternative mechanism under Part 12.
It was, because Part 17 is also the mechanism whereby you distribute profits. That is as close to as a UK law dividend as one can be. And what one sees in the case law is there's a certain presumption or assimilation of UK company law when one's looking at a foreign legal system. But occasionally that system bumps up against something weird. And in the case of Ray and Lazard, that was this concept of a distribution and partial liquidation. And so that requires a bit more care to understand, well, what is actually going on here? You could say also the same in Coulthard's, where the Italian system of share premium is very strange because you're not at liberty to distribute it until something else is being topped up, in which case then you can distribute it, but not as a dividend. So, but with no real formality, I suppose, once you have hit that top up on your legal reserve, I think is the name, at least the translation of it. So the general approach you can see in the case law is, yes, this maybe it's a parochial sort of presumption of our courts, which say, well, there is these two basic type of transactions which a company can entertain, and we are going to try and analyse foreign legal systems by reference to that broad dichotomy. But we'll obviously have to take into consideration peculiarities of our foreign law as and when we come up against them. And the question is, really, in this case, and I suppose potentially in future cases, what one is witnessing generally in corporate law is a sort of menufication of corporate law, i.e. allowing shareholders or businesses to do roughly, be at greater liberty to do what they want in terms of how they return cash or assets to shareholders. And, you know, still applying our 20th century case law, which is the law. How does one apply it? And as the FTT colourfully puts it in this case, share premium in Jersey, you can do what you want with it. Ultimately, you can either return it via Part 12 or you can return it via Part 17. And what Mr. Gammy hasn't said, because I think it's important to note, is his oral submissions have departed from his skeleton. He said the UT had an error of law in applying the corpus test, whereas now he accepts it's relevant but not determinative. I'm not sure how one reads that into the statute, but that is, I think Mr. Gammy accepts you can at least have regard to the old corpus test. But as we all see, and as we saw in First Nationwide, the focus, certainly of the Court of Appeal in that case, was still on the mechanism. As antiquated or as unsatisfactory to Mr. Gammy's mind, that may be. So just in terms of turning to my, before I turn to each of my 3 points, no change in the law, mechanism is king, and what is a residual dividend of a capital nature. The other point I think it's worth just engaging with is what relevance does the trust case law, which we've also padded out the authorities bundle with, what relevance does that have? And I think the best place to find some commentary on that is Lord Reed in Reed's Trustees, at page 421. Just turn that up. It's about midway down the page, just above the highlighted passage. In some cases, the dividing line between capital and income is not the same for the purposes of income tax as for trust administration, but I see no reason why that should be the case. If a dividend ought to be regarded as income as between life renter and fiar, so that's life tenant and remainderman in English law terms, I think that points to it being income within the meaning of the Income Tax Act, but it is not conclusive. So essentially saying it might be useful. And I certainly wouldn't demur from that. So if I can just turn to the first category of submission I want to make, which is that there is no change in the law. I quite accept what Mr. Gammy has said, that there has been a change to the structure of how Schedule D, Case 5, is now taxed under Itoya. Absolutely accept that. But when one is looking at 402, first of all, as we know, it's not listed as one of the minor changes which are referred to in the preamble to the Act. There's just a gap where one would expect 402 to be between change 84 and change 85. So other bits of dividend taxation are being tinkered with, but not 402. What Parliament has clearly done, my submission, is try to preserve the old law in terms of the taxation of foreign dividends, albeit it's got a specific charge for foreign dividends in circumstances where it was previously part of an umbrella charge under Schedule D, Case 5. That doesn't mean that the test is somehow radically different. Furthermore, we obviously know from the explanatory notes themselves, which were to the bill as well as to the Act, that the specific case law we ourselves are engaged with was what the draftsperson had in mind. So we have Reed's Trustees and Ray and Lazard. I don't need to take you back to it again. That case law and the test of corpus is specifically, as well as a quote I think from Whiteman and Sherry or Whiteman on income tax. So all of the pointers are to there being no change in the law. Now, obviously, the language has changed. We have, obviously, the splitting out of dividend in circumstances where we just had income, but dividend is just a form of income. And then all we have is of a capital nature is excluded from that. But unless you can be persuaded, and I don't think Mr. Gammy is, to be fair to him, tried to persuade you, unless you're persuaded that of a capital nature means something different from the old or the conventional distinction between capital and income, which exists generally in tax law as developed by the courts, and in particular in the context of dividends, unless you think Parliament is coming up with a separate, an entirely separate concept from that, then it must follow that it is both permissible to look at the older case law, but more than that in my submission, given that this is a matter of law, that case law, insofar as it does address that question, must be binding on you, to the extent it's either the Court of Appeal, see First Nationwide, or a higher court such as Ray and Lazard. Of course, if you think of a capital nature is introducing some novel concept, then understandably it must be that you can ignore that law. But Mr. Gammy's submissions has rather been based on embracing Ray and Lazard and so forth, rather than trying to come up with a new alternative. So that's, I think, all I need to say on whether there is a change in the law or not. We obviously have, I think my lady's suggestion, a supplementary bundle of authorities, such as Derry and NCL investments, and this debate about, well, is it permissible? You can't look back at the previous text of the previous statute. No one's actually suggesting that here. All we're asking you to consider is the previous case law on what capital and income means in the context of a dividend.
Well, it is whatever acknowledging what the Supreme Court in NCL said, it shouldn't be assumed, or some caution, sounded a note of caution, I think, were the words. We've got the added feature here that the specific case law is referred to.
Indeed. I mean, what more, I ask rhetorically, could Parliament have done to say, please look at the old case law? This is not a case, I would emphasise, this is not a Barris principle type of case where Parliament has enacted exactly the same word and then plonked it into the new statute and said, and then one infers that it's accepting the court's previous determination of what those words meant. That's not this case. Rather, as is quite common in the Taxes Acts, Parliament has had recourse to the concept of capital and or income, and that is a concept which has been commented on, one might say ad nauseam, by the previous courts. It's not a question of looking back at the previous court's case law as to interpret what the previous enactment meant. It's more concerned with the free-floating concepts of what is capital and what is income. And obviously, when one looks at Centrica, the Supreme Court had no difficulty at all in considering that question in the context of expenditure, in looking back at the previous case law. So I note the warning, my lady, in terms of NCL, but in the particular context of this case, and in the context of both the type of case we're asking to look at and what is said in the explanatory notes, in my respectful submission, it is permissible to have regard to it. It would also, if it were otherwise, it would lead to a slightly odd consequence, which is, let's assume it's impermissible to look under the previous case law for that statute. So, the context of capital and income in the context of income tax. Does that also mean that it would be impermissible to look at the trust law case law by analogy, or is it permissible to look at that but not to look at the actual tax cases? I mean, that would, in my respectful submission, be an absurd situation to be in. So, in terms of my second point, in terms of the test of mechanism brackets the corpus test, as I've said, the courts have focused on the mechanism of distribution, and this determines the income or capital nature of the receipt. And that includes considering mechanisms which may be novel to UK company law. And where this is the case, the task is to understand what objectively is occurring in that foreign legal system, as opposed to, for example, simply following the label which that foreign legal system might use. So to adapt the adage, mechanisms and consequences speak louder than labels when one is trying to analyse what is going on in a foreign legal system. And in the context of share premiums specifically, there has been, we can go through the cases on it, but this has been something which is essentially ambiguous and subject to how the local law treats it. So we've got the following cases to consider. We have the trust case of Duff, which Mr. Gammy mentioned yesterday. We have Courtaulds, First Nationwide, and of course this case. And in my respectful submission, to say it's chameleon-like in character, which is what the FTT concluded at 227, and which was endorsed by the Upper Tribunal at paragraph 67 of its decision, that is the correct characterisation of it.
Sorry, UT 67.
Indeed. As part of this exercise, we will also see that the source of the dividend or distribution is irrelevant. Equally, the treatment in the hands of the company is also irrelevant as part of this analysis. So with that sort of overview in mind, I would now like to actually turn up the case law, and if we may, turn to the authorities bundle, tab 21, where we have Reed's trustees. And the following points to note. First, at page 407, at the bottom of the page, about 8 lines up, do you see the passage there? My lords, I must say with great respect that I think that this conclusion can only be reached by ignoring that what may be regarded as capital in the hands of the payer may yet be income in the hands of the payee. So it's on my list of why you don't necessarily get a symmetry. This is actually a point made in NCL Investments itself. In tax law, simply because capital or something is paid out as capital, held as capital in the hands of one person, does not mean that it's necessarily going to have that character in the hands of the recipient. That's just a broad statement, but obviously in the context of a dividend case. Then, if we carry on, this is a passage which is quoted quite a lot, as we see in the subsequent case law at 409. We see the test of corpus mentioned by Lord Simmons. So in the highlighted passage, sideline passage, I cannot imagine a safer or better one, where the question is as to income arising from a foreign possession. So it's not just shares, but any foreign possession, than to ask whether the corpus of the asset remains intact in the hands of the taxpayer. So that's the corpus test as we see it. If we then go on, 410, we're at Lord Norman. We see the statement, the payment was quite properly described as a dividend, and a dividend is at least prima facie, so this gets picked up by Lord Justice Moses later in First Nationwide, prima facie income of the recipient. In law, capital cannot be returned to shareholders by a mere money distribution, whether called a dividend or some other name. And then finally, if we come on to Lord Reed, where I've already taken to the passage talking about the relevance or otherwise of trust law. But if we come on to page 421, crucial question in this case must therefore be decided with little assistance from authority, because this ultimately is the first tax case dealing with this issue. There have been a couple of predecessor ones, but this is the one which is most relevant for us. It is admitted that if money had been paid by reduction of the share capital, that would not have been income. So same concession made by the revenue in that case as was made below. The shares would not have remained the same. It is also admitted that if surplus profits had been used to create bonus shares, or even if it may be bonus debentures, there would have been no receipt of income. New capital assets would have been created. So what Lord Reid there is acknowledging is there is a certain flexibility, even under the company law as it was then, for a company to turn, if one takes gold as capital, lead as income, companies can turn gold into lead and vice versa through their own internal mechanisms. But in terms of what is actually going out towards the taxpayer, one has to focus on that rather than how was this, for example, funded. And then that point is reiterated again over the page, 422. There are many ways in which a company can deal with its profits. If it adopts certain methods, the result is the creation of new capital assets. If it adopts other methods, the result is the receipt of income by its shareholders. In either case, it is immaterial whether the profits were trading profits or capital profits. And again, emphasised at the bottom, I can find no satisfactory alternative to the view that if a foreign company chooses to distribute its surplus profits as dividend, the nature and origin of those profits does not and cannot be made to affect the quality of the receipt by the shareholder for the purposes of income tax. Now, what Mr. Gammy might say is, well, that's all to do with capital profits as opposed to income profits. But in my respectful submission, that stands just as good when one is considering share premium. So that's Reid's trustees. I think in terms of time order, it's also what then happens between Reid's trustees and Ray and Lazard is the case of Duff. So I might as well just deal with that now, if I may. And Duff again emphasises, my learned friend Mr. Gammy was saying yesterday was, well, Duff shows you that share premium does take on this very different quality after the change in the Companies Act 1948. In my respectful submission, one has to ask why. And the why is provided in this decision. And the why is because it forces one to use only the mechanism for capital reduction. That's why it's capital, not because of some sort of holistic characterization in a vacuum of what share premium is. My respectful submission, this is just a very practical judgment as to identifying what is the mechanism used, therefore it must be capital. So if we just turn the bundle up at page 432, we see some basic facts set out. Do you see there, it says in 1950, the company passed a special resolution to pay out the share premium account in respect of each of the fully paid shares. The reduction was sanctioned by the court. And in pursuance of that resolution, X amount of money was paid to the bank in respect of the trust holding. So what we're dealing with here is an absolutely common or garden capital reduction exercise. The fact the subject matter is share premium is happenstance in my respectful submission. The treatment is because of the mechanism. And if one turns to then the judgment of Lord Justice Jenkins, at page 434, you'll see he then makes an appearance in Ray and Lazard as Lord Jenkins. If you see there appears to be little doubt that if before Section 56 of the Companies Act 1948 came into operation, the company had distributed amongst its shareholders in cash a sum representing premiums received on the issue of shares, the proportion of such distribution attributable to any trust holding of shares would have been income and not capital. So he's talking about the previous position, but now it's changed. And as I've said, the question one always has to ask is why? And the why comes a bit later. Sorry, I've just lost my place. The why comes later at page 436. there he's answering us. He's meeting a submission made by Mr. Walton. What Mr. Walton is saying, well, the Act does not, in terms, come out and say this is capital. And what Lord Justice Jenkins says in response to that is really the highlighted passage. I'm not going to read it all out. Can I just invite the court to read that?
What on the page? From halfway down.
Yes, please. Up until this seems to us. So what Lord Justice Jenkins is saying there is, so what if the Act doesn't deem, or whatever label one wants to use, share premium as capital? It's restricting one to using a mechanism which is essentially the same as capital. The mechanism which is used in this case, which is the only mechanism he's being asked to comment on, is a reduction of share capital, or reduction of capital, which is what the statute requires you to use. Surprise, surprise, the receipt is capital. And you see that point made again at page 438. Just above the highlighted passage, do you see that if the terms of section 56 are concerned, as Mr. Walton submitted, with the mechanics of the distribution of premiums received on the issue of shares, still the mechanics are, in our judgment, an essential factor in determining the character as between capital and income of the sum distributed. Mechanism is king, even in a trust law context. And then lastly, page 440, just above the second sideline passage, the effect of section 56, however, is to make a distribution equivalent in law to an actual return of paid up share capital and capable of being effected only through the medium of precisely similar reduction proceedings. It may therefore be said that section 56 recognises the essentially capital character of premiums received on the issue of shares and gives effect to it by investing in any distribution of share premium accounts with the character of a capital distribution carried out. Now, what Mr. Gamby did was quote that bit, but not the why. The why is because the mechanism the Act uses to allow one to make a withdrawal of share premium. The Act, company lawyers don't agonise or navel gaze over whether something is capital or income. Company law says you have to use this mechanism for this pot of cash, or this notional pot of cash, and you have to use this mechanism for that pot of cash, and you can have some flexibility between the two. So all that Lord Justice Jenkins is saying is he is not navel gazing and saying, oh yes, the Act in abstract is characterising share premium as capital. He's analysing the Act and saying, well, the only mechanism which the Act now allows you to distribute share premium with is via a reduction of capital. Therefore, because that mechanism is the only mechanism one is allowed to use, the receipt can only be capital in nature, regardless of what the law was before. There is not a sort of separate, sort of holistic or substance-based analysis.
I'm just not sure that the passages you're showing us here fully bear out your headline about mechanism. I mean, the last sentence there is whether the origin of the account or the mode and character of its distribution be looked at. It appears to be a rather more all-round approach, doesn't it? It seems to be strong evidence for the proposition that how a company chooses to distribute is a matter of essential importance, but it's not the only matter. Isn't that what this is saying?
I wouldn't necessarily accept that's inconsistent with my case, my lord. But
I
what
wasn't saying it was inconsistent. I just was suggesting that I'm all for sloganising, but the idea that it's the only thing that one can look at would not be right, is it?
But my lord, my case isn't that it's the only. It has to be the starting point. It is probably the subject to some override for a sort of Sinclair and Lee type situation. It is going to be the determining factor in my submission. And I think read fairly in the context of the other passages I've taken to you in the judgment, there is clearly an absolute focus on the mechanics which Section 56 of the Companies Act 1948 is forcing one to use, and read fairly in my submission, the judgment as a whole, that is what is determining the nature of the receipt in this case, as opposed to some holistic characterisation of share premium. So I think that's all I want to say about In re Dove. If we can then turn on to Ray and Lazard, so that's behind tab 24, it starts at bundle page 441. Just for your note, the relevant bit of Maryland law is set out at page 446 of the bundle. I don't propose to take you to that, but just so you can understand what they're talking about in terms of the underlying law. Essentially, there was an innovation in Maryland law. So prior to this act coming into force, Maryland law was very broadly very similar to UK company law. And then what had happened was there had been this innovation, which allowed one to have a distribution in partial liquidation. That's basically the background context. And really, the piece of the judgment I'd like to take you to is at page 453. Where we have Lord Reed say, in deciding whether a shareholder receives a distribution as capital or income, our law goes by the form in which the distribution is made rather than by the substance of the transaction. Capital in the hands of a company becomes income in the hands of the shareholders if distributed as dividend, while accumulated income in the hands of a company becomes capital in the hands of shareholders if distributed in a liquidation. Now, again, he's commenting on the potential mutability of capital and income within a company, but ultimately what one has to look at is how it comes out. He then goes on to comment on, well, there is this novel concept under Maryland law, which is a distribution and partial liquidation. And the question is, well, how do you analyse that for UK tax purposes? There is then a sort of discussion. We asked the question, so why are we to hold something to be a dividend, which by the law of Maryland was not and could not be a dividend? So there was an express finding below that what happened could not in fact have been carried out by way of dividend. So that it wouldn't have been legally possible, was the finding of fact below. And essentially what one sees is an approximation of a partial liquidation as being similar to a capital reduction, albeit one which is partial, which would be novel for UK company law. And if one turns over to the following page at page 454, you can see here that corpus and mechanism must mean the same thing, because the passage I've just taken you to at the beginning, our law goes by the form in which the distribution is made. And then if one turns to then just above again the highlighted passage, accepting as I do without reservation, the question is whether the corpus of the assets or the shares of the company or the capital of the possession did or did not remain intact after the best of all shares were distributed, or whether the best of all shares were merely fruit. So we then get all the slightly more abstract analogies. But Lord Reed is not suggesting a different test. He's saying it is, in my respectful submission, the same test. And then touching upon my lady's question earlier, as to what is the role of foreign law, we see Lord Reid comment, it is not disputed that the nature of a taxpayer's right to his foreign possession must be determined by the foreign law. See Archer, Shee and Garland, that was obviously a trust case, trying to determine what was the nature of the trust, the foreign law trust. We must go to the law of Maryland to find whether the taxpayer's capital asset remained the same, and it is found as a fact that it wasn't. And you see the quote there. And so the plain meaning of that finding of fact is that after the partial liquidation, the corpus of the respondent's capital asset did not remain intact, even though that mechanism was not possible under England, under UK company law. And so we get the analogy with trees again, that in Maryland you can split them in half and that's okay, whereas in England you can't. So that's Lord Reid. Lord Jenkins also makes an appearance, as I said, but there's nothing I want to refer to there. But if I may, can we go on to Lord Guest, page 456? And again, we see Lord Guest state the test. Bottom bit of the first sideline passage. The character of a payment in the hands of a shareholder in this country is determined for all purposes by the legal machinery employed by the company acting under the relevant statutes. And so again, there's a reference made to an earlier tax case was Blot, which my lady may recall is all to do with bonus shares and whether that was A, even a distribution, or B, if it were a distribution, whether it was income in nature.
Neither, as I recall.
So again, an emphasis on the mechanism test by Lord Guest. And then finally we come to Lord Pearce. So starting at page 457, by the highlighted passage, he starts off by quoting Lord Reid in Reid's Trustees. But then if we go over the page to page 458, we see Lord Pearce say, thus, it is not the source from which the assets are distributed, but the machinery employed in their distribution, which determines the question whether they are received as capital or income. Let's see another quote from Blot. And he says, if, however, they are distributed in any other way, they are received and taxable as income. So that's the test as far as Lord Pearce is concerned. But he acknowledges it is possible for a new statutory method of distribution to enlarge the categories of possible capital distribution set out. And then he obviously is citing permanent trustee, which seemed to give a very restrictive means of giving a return of capital. And the case he cites is in Reid Duff. But note, just in answer to my Lord's earlier point, as far as Lord Pearce is concerned, it's because there's a new mechanism which has been produced, which gives rise to the result in Reid Duff. And then last, there's a comment about, well, what if the assets themselves, which are distributed, are shares in another company? Well, that's going to be just a distribution of money's worth, and so it's just going to be income in nature as well. That proposition is not disputed by Mr. Gammy. So that's Lord Pearce. Again, I would submit you have both Lord Reid, you have Lord Guest, and you have Lord Pearce in this judgment. Each of them emphasising mechanism. And then last, if we carry on with Lord Pearce, page 459. Again, this answers, or at least meets my lady's points. So the passage above the sideline passage, do you see that? The question whether receipt is income arising from possessions out of the United Kingdom is a question to be determined according to English law, but it cannot be decided in vacuo. The factual situation, which includes the foreign law, has to be examined in order to apply the English law. So, and then he obviously cites in Garland and Archer Shee, which is, I think, the case Lord Reed had also cited above, where Mr. Justice Rolat is quoted, the question of American law is what are exactly the rights and duties of the parties under the American trust? And when you find out what those rights and duties are, you see what category they come in. And then he goes on to comment that because a company is essentially a legal fictional person, it can only behave and is governed by the laws under which it's incorporated. And then goes on to comment on the peculiar mechanism under Maryland law. He also then makes the point, in the present case, that conclusion accords with the commercial substance of the transaction. And then, but he leaves open the possibility that it might well be permissible for the courts to look behind the mechanism in certain situations. So you see that if such a situation arises, it may well be that the English courts would feel entitled to look behind the labels or even perhaps behind the machinery itself to find the true substance of the matter. So I think what Lord Pearce is doing there is leaving some judicial wriggle room, and it is, in my submission, the same wriggle room which the draftsperson of 402 is envisaging with the idea of potentially a dividend of a capital nature, or at least in part, because obviously there might well just be, as my lady has commented, some novel form of foreign law which has a dividend, but it could still be said to be, in substance, a capital dividend. So that's Ray and Lazard. Just coming back up to the passage above with Lord Pearce and the quote from Rolat, in my submission, that is helpful because what Mr. Justice Rolat there is commenting on is what are objectively the foreign law characteristics of, in that case, trust, but in this case, the mechanism of what is occurring. One is, I would make the submission that one is not necessarily governed by the labels that foreign law has. One has to look at what are its objective effects, it would be my submission, because labels will mean different things to different lawyers in different jurisdictions. And obviously the test we are having to address is going to have to be applied not only to something like Jersey law, or maybe even US law, where the language might at least superficially look familiar, but potentially a Chinese dividend or a dividend from South America. And there, one is instinctively not going to try and see what label one has, but one shouldn't be fooled into thinking that just because it's an English language system, that their concept of capital or whatever is the meaning of capital which our case law is trying to engage with. So that's Ray and Lazard. We then have the case of Courtaulds, which I don't think Mr. Gammy actually took you to yesterday, but that's at page 460. And what we have is a case stated in terms of the underlying facts, and ultimately a translation of what happened below. But the actual findings of the commissioners are set out very briefly at page 463. Do you see it, number 6, the commissioners decided?
We look at the tax cases version of this case.
We're looking at the weekly law reports.
Yeah, because the tax cases version will have the full case stated.
It does. I have looked at the tax cases version, my lady. I'm not sure on this particular point there's much more there.
Right, so 463.
So under the provisions of the relevant Italian law, the reserva sovrapprezzo azioni is a reserve equivalent to a share premium account in English law, and a return to shareholders from the RSA, as I'll call it, is a return of capital under Italian law. Now that is quite a compressed finding, which is the point I'm making, because does that mean that Italian law regards the share capital of the shareholders as permanently affected by this exercise? Because that's really the proper question to ask. What Italian law thinks is capital is not relevant in my submission. It's what is the objective foreign law characteristics of the mechanism which has actually happened. And that's all compressed into a little phrase, is a return of capital. And then there's a discussion about the Companies Act prior to 1948. And you can see all the case law we've been through. And according to the evidence, the property rights of the shareholders in SNIA after the receipt of the sum in question remained unchanged. Again, I'm not really sure what that's supposed to mean. But what one sees is when it comes to the decision of Mr. Justice Buckley, you can see the narrative start at page 465 by the sideline passage. And then, crucially, the finding just by H, this, as the Commissioners found, constituted in Italian law a return of capital, and so was not subject to the Italian withholding tax on dividends. And then you see the further finding there in paragraph 311 of the case stated, a share in an Italian company entitled the shareholder to an undivided interest in the capital, reserves and assets of the company, but not to any specific part thereof. If the share premium account were distributed, the holder of the share would be entitled to the same rights as before the distribution, though the value of the share would be diminished. So again, that is quite an ambivalent finding, I would respectfully submit. And to be fair to Mr. Justice Buckley, he found the status of the share premium to be not clear. And we see that at page 470. So he's first talking about the legal reserve. So if you recall, the legal reserve has to be topped up before one can even distribute the share premium. He's quite comfortable that the legal reserve is part of capital, but he goes on to say the position in this respect of share premium reserve of an Italian company is not perhaps quite so clear. But he ultimately finds that it is regarded as part of or the exercise used in terms of the distribution of it was a return of capital. But in my respectful submission, this is quite a borderline case, and with different Italian evidence, who knows, the result might have been different. But obviously, what was or historically was the position under Italian law and the peculiarities of the Italian company law system obviously does not transport itself over to our case. And I suggest that on the facts of this case, it really just turns on its own facts, or at least the facts of foreign law as found by the commissioners in that case. You can see the conclusion really at H on that page 470 on the true view of the facts. I think that share premium reserve stands in the same position. Italian law demands that this fund be set aside and that it is not distributed at all, so long as the legal reserve is less than 20% of the share capital, and that when the legal reserve has achieved that level, the share premium reserve may be distributed, but only apparently on the footing that the distribution is treated as a return of capital. So there's still, unsurprisingly, because obviously Mr. Justice Buckley is bound by all the previous cases, he's still engaging with mechanism there, but he's just finding that on balance, because of the way the Italian law mechanism works, which is certainly peculiar to our eyes at least, it's still going to be a capital receipt. In particular, do you note, it seems no legal formalities need to be fulfilled to justify distribution. But it is not using the same mechanism, for example, as a distribution of profits. I don't know if it helps as well, but just in terms of the terminology of assimilation, you see Mr. Justice Buckley use that language, certainly at F on page 471. So it may well have crept into the discourse in First Nationwide as a result of that. But it's obviously not a term of art, it's just asking whether something can be regarded as part of the share capital or not. There is then the First Nationwide cases. I'm obviously going to be focusing particularly on the judgment of the Court of Appeal, but there are also some parts of the Upper Tribunal that I think are worth just taking you to as well. So if we just turn up First Nationwide, tab 32. And paragraph 26, which is on page 612. So this is a decision of Mr. Justice Warren and Judge Sadler. And paragraph 26 is just making that same point again, that simply because something is capital in the hands of the payer does not necessarily mean it's going to be capital in the hands of the payee. And a Privy Council decision is cited for that proposition there. And a quote from Lord Millett. And then the next passage I would like to take you to is 104, which is on page 630. This is what this is engaging with an argument from Mr. Gammy, where the suggestion appears to be that because distributions could be made by way of capital on a winding up, the true nature of the share premium account is seen as capital. So that when it ceases to be made available on winding up because it has been distributed as dividend, there must therefore have been a change in the corpus of the estate. So it's engaging with the argument, well, if you use a different mechanism, it might have been capital, therefore you should still regard it as potentially capital, even though you've used a different mechanism. But as Mr. Justice Warren and Judge Sadler say, well, that is essentially a bootstraps argument. And again, essentially focusing upon the potential flexibility of concepts of capital and income within a company, which is distinct from concepts of capital and income in the hands of a recipient of a distribution, which, as my main submission is, that is down to the mechanism used. And indeed, if one skips back up, I apologise for jumping around, but if one goes back up at paragraph 50, which is on page, it ends on page 618, you can see at least in the Upper Tribunal, this is not reflected in the Court of Appeal, but in the Upper Tribunal, you can see the passage highlighted there. It will be noted that under our approach and analysis, the categorisation in Cayman law of the share premium account as capital or profit is not relevant, nor is it relevant whether Cayman law would treat a dividend paid out of share premium account as income or capital in the hands of the recipient. In case we are wrong on this, we consider the appropriate categorisation later in this decision. So that is perfectly understandable, of course, if one is focusing on the mechanism. That is essentially meeting the same argument which Mr. Gammy, this time with a different hat on, this time for the taxpayer, is trying to make in this case. You have to share premium internally within the company is indelibly capital, so therefore it doesn't matter what mechanism we use to get it out. It has to be a capital receipt. My respectful submission That's inconsistent with all the case law we've seen on mechanism, and that this is the cleanest area I've seen that point met head on in the Upper Tribunal. So then, just to complete the tour of the case law, if we can turn to the decision of the Court of Appeal, so that's tab 33, page 642. And if we turn up paragraph 10, we see, if I can just invite you to read that. Up until Hill and Permanent Trustee. And indeed, such is the emphasis of the mechanism in this case, I do not believe Lord Justice Moses even mentions the word corpus. Very happy to stand corrected when I'm wrong about that. And again, if one jumps ahead a bit to paragraph 16.
Well, he mentions corpus in the quote in paragraph 10.
Oh, he mentions it in the quote, but I don't. So, apologies, my lord. He, in terms of his own reasoning, he doesn't use that term.
Yeah, paragraph 22. I mean, just
No?
it's scattered through paragraph 22, 24, and so forth. It may not matter, but
happily take the point. Yeah. Before one gets there, if one goes to paragraph 16, we see Lord Justice Moses identify that the form of distribution dictates its character, and he bases that on the two passages from Lord Reed. And then if one moves on just over the page to little b, he again uses the language of that conclusion was dictated by the machinery by which the shares were distributed. So again, focusing on machinery. And then at paragraph 18, the principle that it is the machinery by which the assets are distributed, which determines whether they are capital or income, finds expression yet again in Coulthard's. So certainly Lord Justice Moses does not think Coulthard's is a sort of outlier by applying some sort of different analysis. It'd be surprising if it did. I think then, if one looks at 22, he's recording Mr. Gammy's argument. So 21, you see, not so, says Mr. Gammy for the revenue. And he says 22, the articles accordingly, I think this is still Mr. Gammy's argument, very happy to stand corrected, that the share premium was part of the capital corpus of the company. That corpus was not left intact. That's obviously completely at odds with the decision, because the decision says mechanism is king. By implication, if one were to consider corpus, it must be that the corpus was left intact. So I think these are Mr. Gammy's words rather than Lord Justice Moses, but I accept it's not clear. And then lastly, at paragraph 26, Lord Justice Moses acknowledges at this point that dividends are prima facie income. So there may well be circumstances where they're not going to be regarded as such. And if you see there are cases where on a true analysis of the facts, it is possible to identify a declaration of a dividend as being other than a payment of income, and Sinclair and Lee is the case cited.
So this was the point that I asked Mr. Canny about yesterday, which is what was the significance of the fact that the appeal, there was no appeal in relation to the character of the Glencore distribution as being dividends. I mean, in other words, the idea of a dividend is it does carry some colour.
It absolutely carries more than colour. I think it's almost a presumption unless there's some overriding factor when one's standing back and maybe looking at the substance of what has actually occurred, which would mean that one...
So in other words, the fact that that point is now conceded is not simply neutral in the matters that now have to be decided.
No, my lord, it's not as if the draft on a proper interpretation of 402, having regard to the prior case law, the draftsperson is thinking, well, there are some dividends which are capital in nature, there are some dividends which are income in nature, who knows, it could be either. The proper approach is, if it's a dividend, it's prima facie income, unless you can identify some other factor which essentially disturbs that presumption. And you can see that on the facts of that particular case, no such analysis is possible. So there's a rejection that this is somehow similar to Sinclair and Lee. And then the judgment then goes on to discuss the repo issue, which we're not concerned with. So what I hope that sort of tour of the case law has demonstrated is that, yes, there is some discussion of corpus. There is, but if one reads that case law consistently, and certainly by the time you get to Lord Justice Moses's judgment, there's no doubt that it's really the start and the end point, unless you're in a Sinclair and Lee type situation, is the mechanism.
You emphasise the mechanism rather than the corpus point, which of course is the concept referred to in the expansion notes. I infer that that is partly because there may be a bit of difficulty in applying a corpus test if it's something different to this case, given the submissions, well, putting to one side what the FGT actually found, we've got the Jersey law that tells us in particular that share premium account has to be kept separately for each class.
Yes, I accept that. It has to be kept separately from each class.
And the revenue accepts, you've confirmed that if it was returned under Part 12, it would be a repayment of capital, it would be capital.
Yeah, I'm not seeking to demur from that.
Yeah. So I'm just trying to understand. I think it might be quite important that you're emphasising mechanism over corpus, even though you say they should be understood as being the same.
Yes, I am. I suppose when one uses the language of corpus or fruit and tree,
Yeah.
Mr. Justice Warren was quite rude about all of this. It is naturally imprecise language to use and may well be in the eye of the beholder. What I've also attempted to demonstrate is that corpus, as used in the explanatory notes, can only be a reference to the case law which focuses on mechanism. And they are not different tests, they are the same test. It is very difficult in my respectful submission. We know that Ray and Lazard is referred to in the explanatory notes. In my respectful submission, it is impossible to read Ray and Lazard as asking an open-ended question about corpus, and as opposed to focusing primarily on the mechanism. And that isn't just, as it were, my own take on the decision. That's obviously Lord Justice Moses's interpretation of it. So, yes, First Nationwide post-dates Itoya. It is obviously a decision under the old law, but it is, a decision of this court summarising what that case law means in the context of a foreign dividend paid out of share premium. Now, Cayman law and Jersey law are different, and there is, particularly in different in how share premium is treated. There's a menu in Jersey as to what you can do with share premium. There is no such menu in Cayman. That is a distinction which makes no difference, in my respectful submission, to the proper analysis. It's obviously a distinction which Mr. Gammy clings to, because that is the only point of distinction really between this case and First Nationwide. And hence he is compelled to try to attack the findings of Jersey law and the conclusions drawn from it by the first instance judge. But in my respectful submission, that is a very difficult challenge to make. It really rests upon the import of Article 39 sub 4. And if you recall the discussion yesterday, there was a reference made to Article 115, which says this isn't going to be a reduction of capital for the purposes of Part 12. Ms. Gamby says, but that's only for Part 12, whereas the deeming in Article 39 sub 4, and it is a deeming, his own experts use that language as recorded in the decision. I can take you to that passage. It's limited deeming for thee, absolute categorization for me, is what he is saying, in terms of how one treatment of the mechanism of paying out share premium is regarded versus what its overall status might be as a matter of Jersey law. But after all, the only way to Part 12 was, leaving aside Part 11, which is about redemption of shares, Part 12 is the only identifiable way in which Jersey law allows one to return capital. Or at least the paid up share capital. Now, the other point Mr. Gammy makes is, well, what the learned judge below did not do was engage in a detailed comparative exercise of what would happen if we didn't in fact have a company like Glencore, which has nominal share capital, but was a no-par company. And therefore, we then had a train of reasoning which says, because of the treatment of no-par companies which don't have any nominal share capital, so it can all be paid, it can all be debited to their stated capital account is the language used. It must be, all of that must be capital, because the legislation doesn't sort of hive off any element of it which can only be returned under Part 12, as opposed to some of it which can be returned under Part 17. Therefore, the judge must have been wrong in terms of her analysis of a completely different company which did have nominal share capital. But in my respectful submission, that doesn't come remotely close to being a sufficiently grave error of law. It was no error at all, but can disturb the judge's findings in relation to in relation to what was a distribution under Part 17 in relation to a company with share capital. Now, it's fair to say the no par value analysis was, I think, set out in a commentary by Mr. Felton, the appellant's expert, in the joint memorandum. But there is nothing which I think Mr. Gammy has identified, either in terms of his own commentary on the statute, let alone in terms of the underlying evidence of foreign law, which says the judge should have been compelled to identify that in the context of, not in the context of a no par value company, let's just look at the facts of the company which we do have, which is treated differently under Jersey law. There's no doubt about that. That in relation to that particular company, why, if the statute allows you to return some parts of its capital via Part 17, but for some parts of its capital, the only mechanism one can use is Part 12, that one has to somehow equate the two. Of course, you could reorganize your nominal value company into a no par company, absolutely. But company law allows you to do lots of things, but ultimately what tax law is concerned with is, under the mechanism used, what is the nature of the receipt? And what the in my respectful submission, as the Upper Tribunal said, in an unimpeachable way, yes, there are infelicities in terms of how the findings of law are set out in the decision, and sometimes there are infelicities in terms of the terminology used. I quite accept that. This is not an exercise in proofreading a decision of the FTT. What we have to find is an error of law which is sufficient to invite this court to superimpose its own view. And I'll obviously read Mr. Gammy's note later, and I would have to reserve my right to reply to that in writing because I can't possibly digest this, and Mr. Gammy still hasn't explained which is the error of law, which he relies on, and which are just infelicities, and it's not supposed to be a treasure hunt for the other side to figure it out. But what Mr. Gammy hasn't done is to say, well, he hasn't demonstrated that what the tribunal has analysed just in the abstract as between part 12 and part 17 was not a finding open to them. My respectful submission, that has not been done. And then, in terms of his comparative analysis, in terms of no par value companies, again, in my respectful submission, that's Mr. Gammy's opinion. But the fact that Mr. Gammy might disagree, or another lawyer might disagree with the First Tier Tribunal's interpretation of Jersey law is nothing to the point. He has to show that they have made an error of law by making a finding of Jersey law which was not reasonably open to them. And that is the case regardless if one is applying an Edwards and Bairstow light analysis, or if one is even just making submissions de novo, my respectful submission. I mean, I struggle to understand what is wrong with this decision. On any view, a fair reading of that statute is that share premium is flexible in Jersey law. That is the essential finding of the FTT. There's nothing wrong with that. And then all that has occurred is the FTT has then, quite properly, had regard to binding case law on her, which focuses on the mechanism. And indeed, there is then a discussion at the end of the decision, I don't think you've been taken to it, a thoughtful discussion at the end as to, because of this flexibility under Jersey law, does that somehow mean that the previous case law sort of falls apart in your hands because of what the tribunal calls the dualistic approach of Jersey law? And you can see that at paragraph 143. Sorry, page 143 of the bundle, paragraph 262. You've been taken to this already because this is the discussion about Schrodinger's cat. And at 265, you can see the judge's comment. This seems to push the mechanistic approach adopted in First Nationwide and derived from the earlier cases quite some way. It is only having made a choice between two possible methods of payment that the nature of the payment is determined. Well, that's true. I accept that. But that is not a novel feature which has only arisen in this case. It has always been a focus on the manner in which the company is choosing to do something that determines the nature of the receipt. And then there's a discussion at 268 about whether it's the mechanics analysis is meaningless. Mr. Gammy has not made that submission in this court. He says corpus is relevant but not determinative. But ultimately, the tribunal judge's decision at 269 is, having considered all the authorities, underpinned by principles originally expressed in Bouch and Sproul, I've concluded that even in these circumstances, the form in which the payment is made must be taken to determine its character. So even then, when faced with, to use the FTT's terminology, the dualistic nature of share premium in Jersey law, the judge then applies the previous case law quite appropriately and finds that it still has to be applied. And in my respectful submission, there's nothing wrong with that conclusion either. I see the time. I think Ms. Blanche is going to have to address you on the Lonmin distributions. It may well be she's not going to be finished before the short adjournment. I was wondering whether that is going to be a convenient moment.
Where have you reached in your own submission?
I think.
I think I probably need to take you through the Upper Tribunal, because ultimately we're concerned with what the Upper Tribunal has it made an error of law.
Well,
And
we can be flexible, but I just want some vista
in terms of
where we've
well-
reached with your combined submissions.
combined, I imagine we'll be finished by 2:30 at the latest.
Well, I'll tell you what. We'll stop now. We will start again at 2:00. We'll discourage the filing of further paper submissions if that can be avoided. Of course, if you don't think it can, then it can't. But the extra 10 minutes might give you an opportunity to alight on any particularly egregious parts of the document that you feel can't go without notice. I don't mean that disrespectfully, Mr. Kelly, but just an attempt to focus in rather than spread out. And so if you don't feel you can do that, I don't want to deprive you of all sustenance, but it may be possible.
Where's my
Right. 2:00. Thank you.
Court rise in favour.
Yeah. Yeah, I think it's fine. Yeah, yeah. Malcolm, I think this is what Lady Justice Falk was after. In terms of the beginning of the notes to the bill.
Oh, right, this is, oh, I see, yes, I'm with you. I'm with you.
I'll hand that up after lunch.
Yeah, yeah.